Item 701.
But before my learned senior starts, there is a small request. Regarding the scope of the reference. As your lordships, my lord, have now broadly, my lord, seen the papers. My lord, the reference is whether Article 30, sub-article 1, the expression used, establish and administer, is disjunctive or otherwise. Where, my lord, Aziz Pasha will have to be, my lord, addressed. But the written submissions which all of us have received from the petitioner is as if Aziz Pasha is being reconsidered, as if this bench is sitting as an appellate bench. My lord, I have, my lord, in my written submissions,
My lord,
narrated. Only a minute, if I
the
can.
capacity of the solicitor to interrupt and take the stage is legendary. Let us begin, and he will answer, and we will answer him. This is not on, my lord. This is simply not on. If he has raised certain questions, we will answer them.
Let Dr. Dhawan open, because once in about 20 minutes, we'll know what the ambit of his submissions is going to be. Then we will see as the matter progresses. Let Dr. Dhawan open. Let Dr. Dhawan open.
Let us begin, my lord.
Our request, and we have decided to be, my lord, decent, and we will be decent.
Both individually on the issues, quite apart from being disjunctive or conjunctive, that's one part of it. But on the individual issues under Article 30, whether Aligarh Muslim University was administered or, let's read and as or established, on both those issues, the court ruled to say that it is neither administered by minorities or established by minorities. That correctness of the finding has never been referred. Has ever been referred. That's all that we wanted to point out.
That will be your submission. That will be your submission in this.
Yes, that's all.
My lord, whether this reference is sustainable is an argument I'm going to make.
Because in fact,
Because one curiosity.
premise that these.
What is this, my lord? I've never seen this in the Supreme Court.
Mr. Guru, we are now a bench of 7. We are a bench of 7. Let Dr. Dhawan open his argument. As the matter progresses, we'll understand what is the scope of the controversy, and then we will decide where.
This is simply unfair.
Yes, Dr. Dhawan, we'll
No,
start.
in fact, it is fair. We know
No,
that
please,
what is the
Please, one person goes on air, Masha, the other person says the reference is not maintainable. We will address these issues.
You won't be able to.
You answer.
Let us leave
You
it.
answer, and we will answer you. My only request, my lord, is this.
Yes.
There is a certain slack we might require in your lordship's timing. We appreciate, my lord, that this is the busiest court in the world. You are overwhelmed in a way in which no court in the world is overwhelmed, whether it's 136 or whatever it is. The time that your lordship can give, Lord, is very important. And I would just say that in the light of what has been said, our reply is important. In the 370 case, our reply was curtailed, my lord. If required, your lordship may give us time. That's my respectful submission. My lord, I remember G.L. Sanghi was asked to curtail his arguments. Krishna Iyer rang him up in the evening and said, your item is number 1, please continue. These are, my lord, traditions, and I know that the Chief Justice, and I've commended it, is so patient in listening to arguments. It is admirable.
Thank you. Don't worry about the fact. Ultimately, our conscience has to be satisfied that we have heard both sides fully.
That's right, and our reply.
The reason why we set down time limits is because then people have a broad indication.
Lord, I understand.
There's no
I
repetition
understand the
by
need for time
counsel.
limit, my lord.
Yes.
Your lordships are overwhelmed. Now, my lord, let me begin by saying about the reference. I want to read the 2 reference orders to your lordships, because the significant thing in the 2 reference orders is this, that normally when a reference is made, the points of reference are itemized by your lordships. This has not been done in this case. So I've taken the liberty, my lord, in my written submission of itemizing what draws from the 2 reference orders, the first in 81 and the second in 2019. So let me take your lordship straight away to those two particular orders. Because it's important your lordship should itemize what the point of reference is.
We get them in volume 3A, right?
3A, absolutely. Show me both, 209. I'm sorry, I'm a Luddite, my lord. I'll have to use the printed text. So much better. One day, my lord, I will learn. That's a promise. My lord, kindly turn to.
I thought we could have started with this matter.
It should start with this matter. I'm learning, my lord, I'm learning.
Hello.
I am. I appreciate this, my lord. And when I interact with my colleagues, they're brilliant at this in a way in which we never were. Anyway, kindly turn to, what is it? That's the PDF? 209. Lord, this was what said by a bench presided over by Justice Fazal Ali. It says, after hearing the parties, we are clearly of this opinion that this case involves two substantial questions regarding the interpretation institution changes in view of the broad principles laid down in Aziz Bhasha. Even as several jurists, including Mr. Sirvai, have expressed the correctness of the decision of this court, since the point has arisen, we think that it is proper with a larger bench can consider the aspect fully. We therefore direct that this case may be placed before the Honorable Chief Justice for being heard by a bench of at least 7 judges, so that Aziz Bhasha may also be considered and the points that arise directly to the essential conditions or ingredients of the Vinery institution may also be decided once and for all. Then a reference is made to the various criticisms which the court noted. A large number of jurists, including Mr. Sirvai, learned counsel for the petitioner, Mr. Garg, and interveners Dikshit and Taskar, have also stated, Mr. Garg and interveners Dikshit and Taskar have also stated that this case requires reconsideration. In view of the urgency that this matter may be decided as early as possible, we gave liberty to counsel to mention it before the Chief Justice. So here, my lord, is a clear statement. Of course, that reference was not made eventually. But we have now to consider the reference that was made by my Lord Chief Justice Gogoi. Your Lordship may come to 216. The point I'm going to make is there are so many things mentioned in this reference that your lordships will have to formulate, and we will assist your lordship to formulate what the points of reference really are. Maybe all these arguments, the reference is bad, etc., can be looked at after the event. Now, my lord, 216 begins with Aziz Bhasha. In our mind, it's clear that the community will have the right to establish an administrator of their choice, meaning thereby where a religious minority establishes an educational institution, it will have the right to administer it. An argument has been raised to the effect that even though the religious minority may not have been established, it will still have the right to administer. When I get to Aziz Bhasha, my lord, I'll read all of it, but kindly come to page 218. It's a very interesting comment, my lord, your lordships have made, which really, in a sense, takes us much further, where in paragraph 2, it is said the judgment of the Allahabad High Court, which is under challenge, rejects the prayers made on account of the decision of Aziz Bhasha. This is the effect of Aziz Bhasha, that after 1968, it has quelled all understandings of Article 30. Then, my lord, a mention is made of Anjuman Rahmania, which is the 1981 case. And then, my lord, your lordships will see in paragraph 4, it mentions TMA Pi. What is the effect of TMA Pi? It's crucial, my lord, in our understanding of what this is. Your lordships will then come, my lord, to page 219, where a question was raised in TMA. Now, Yashpal, my lord, looking at the UGC Act, which his Bhasha refers to, but nevertheless, it does. UGC Act, my lord. Now, my lord, what do we do with Yashpal? And then, my lord, over the case 221, having regard to the background as stated above, when the precise question was already referred to the 7-judge bench but not answered, we are of the view that the present question set out above should be referred. Now, what is to be taken into account, my lord? TMA Pi is to be taken into account. Yashpal is to be taken account. Yashpal, my lord, says that when you want to establish a university, it has to be done by statute. This is section 23 of the UGC Act as well. Now, the point would be, it means that wherever there is the establishment by statute, you are not entitled to be a minority institution. This will affect a large number of institutions, my lord, in this country. Your lordship is a chancellor, my lord, I want to stress that point because I don't think Aziz Bhasha has understood how universities are administered. Now, my lord, what do we do with the reference? You can pop up and say whatever you like, but we have tried to make, my lord, some sense out of what this is. I've done it in a small paragraph, and will your lordships come to my written submission? Lord, my learned friend says that in 220, Aziz Bhasha has to be reconsidered is mentioned twice. This is there, my lord, in the reference. But unfortunately, that bench did not delineate what the questions are, which normally, my lord, happens. Now come to my written submission.
Of course, the order, the referring order by Chief Justice Gogoi, Brother Justice Khanna and Justice Nageshwar Rao refers to the questions which were formulated in Justice Fazal Ali's original order. Says that, well, those questions were never answered. No.
Question formulated in TMA.
No, there were two questions which were formulated by Justice Fazal Ali. In fact, he began by saying two questions arise.
Yes.
He didn't formulate them as 1 and 2, but it's obvious on the first page the learned judge has formulated the two questions.
But the very fact that it refers to 2MA Pi and Yashpal has to be taken into account, my lord. It's as simple as that, my lord. Now, my lord,
These
finally,
questions were formulated by Justice Fazal Ali is referring.
to some extent, my lord. to some extent. But this court looked at the later decisions of this court.
And the later developments which have
That's
taken
right.
place as well.
Now, my lord, kindly come to my written submission. This is volume 1A.
Because you have the 2004 Act which comes in, then Yashpal is there.
That's right,
And then TMA Pi tells us how do you define a minority? It doesn't
That's
tell,
right.
TMA Pi doesn't deal with establish and administer, but it certainly has some bearing on the issue because it does.
Of course, and its consequences. Because your lordships are always concerned with the consequences of an interpretation. Kindly come, my lord, to my written submission.
That would be volume
The 1A.
1.
But kindly turn to page 7, where I've summarized. I'm sorry.
Dr. Dhawan?
Now, my lord, after what I've read to your lordships, I've dealt that. Kindly come to page 8, 1.5. To my mind, my lord, since Yashpal, and of course there's the National Minorities Act, my lord, which is very important, I have, my lord, indicated what the possible reference could be. And that your lordships will find at the bottom of page 8. May I read it, my lord?
Yes.
Now, my lord, at the bottom of 8, I've succinctly put what the reference should be. Whether the decision in Aziz Bhasha is internally contradictory in its reasoning on facts and law, contrary to the authoritative decisions of this court, rendered nugatory by subsequent statutory changes, and contrary to the constitutional dispensation of Article 30. This covers, my lord, the later portions and the earlier portions. Now here, my lord, I put the issues that arise from this. The first is, was Aziz Bhasha correctly decided, and whether it suffers from internal contradiction and reasoning on facts and law? This, my lord, I'll place Aziz Bhasha before your lordships. Did Aziz Bhasha need to be considered in the light of earlier and subsequent decisions of this court? What is the effect of Aziz Bhasha in the future decisions of the Allahabad High Court, which applies Aziz Bhasha completely and strikes down the statutory amendments through the 81 Act? My lord, when we went to the Allahabad High Court, Chief Justice Ray simply said, this problem of Article 30 and Aziz Bhasha is by a bench, authoritative bench. We have to follow it. There's nothing more we can do. Of course, the judgment is piquant, but we are not at present, my lord, in appeal over the Allahabad judgment. I appreciate that, my lord. We can certainly place it before your lordships, but I don't think it's necessary. Maybe that's in the light of your lordship's decision. Maybe, my lord, that can be done by the smaller bench. Now, my lord, what is the effect of the National Commission of Institutions Act read with the University Grants Commission? Should Aziz Bhasha be reconsidered in the light of the NCMI and read with UGC by Yashpal? Then, my lord, was Aziz Bhasha correct in accepting the antecedent historical data on AMU's Muslim character, but denying its constitutional significance while deciding the issue of its minority status, which is at variance with St. Stephen's, Proust, my lord, and Pathak. Then is Aziz Basha contrary to the constitutional dispensation, my lord? That's the sixth point. These are the issues that arise, and I've dealt with them in seriatim. Because we have to, my lord, whether we like it or not, cull a reference from the two reference orders. Now, my lords, I want to begin by saying, before I go into the preliminary objections that we want to raise, my lord, Lord, I think your lordship will bear in mind that India has a diversity which is more than continents and any other country in the world. Your lordships have listed they have listed only 22 languages in the 8th schedule, but in actual fact there are much more. As you go across even my state of UP, you will see the variation as it goes, and they want to preserve that language. Tulu, my lord, that is the basis of TMI PIEs. Therefore, your lordship will bear in mind that this enormous task before your lordships, which TMI squarely places in talking of secularism, and then there's this very elegant passage, my lord, at the end. Very evocative, my lord, but very important. So when your lordship gets into this question, my lord, your lordship is deciding something that goes to the heart of Indian secularism and to the heart of the diversity of this country, both in terms of language as well as religion. This is so crucial to our understanding of the Constitution. Of course, in 1920, there was no Constitution. But subsequent developments have taken place. In 1950, a Constitution comes. 56, the UGC Act comes. The Minority Act comes. And there's a load of decisions, Lord, which say, look at the historical antecedency. Aziz Basha looks at it and says it's now irrelevant because we have decided that the Act, in fact, established. What happens to that rich history, my lord? Mr. Sibal will also comment on it. What happens to that rich history? Throughout the world, my lord, there are minority state institutions. Your lordship went to Harvard. John Harvard came from Emmanuel College, my college, my lord, and we still exchange with Harvard. If you look at America across the board, and if you look at India today, private institutions and minority institutions are the heart and soul of Indian education. You can't deny it, my lord. And that is why Justice Kripal says, so what if they're aided? They don't lose their minority character. You can't withdraw recognition. This is one of the points that is made in TMAPI. To its pleadings and affidavits in the present litigation in the absence of any change in circumstance or new material. The Union of India, my lord, has always defended the statute. In Aziz Basha, they defended the 1951 and 65 Act. And when we were in Allahabad and before this court, when your lordship gave a stay order, the Union of India took the view that Aziz Basha was wrongly decided. The history should have been taken into account. And how can it change its stance? How can, because of a regime change, how can, my lord, we say that because of the regime change, we change our stance? It can't be done, my lord. I await, my lord, the solicitor's response to all this. And when that response comes, we will reply. But just let me take you to one or two passages on page 10 onwards. What the Union of India does, my lord, in 2.2, in view of the foregoing paras in general and particularly in view of the judgment of the Supreme Court in Aziz Basha, the Union of India has decided to withdraw its earlier stance taken by the government to support the minority institutions status of Aligarh Muslim University. The SLP filed in the Supreme Court in 2006 in support of the minority status of ANU may accordingly be treated as withdrawn. Now, of course, your lordship has to give permission for this. That hasn't happened. We've responded to this as well. Then, my lord, your lordships will see, I've said the Union of India's volte-facing. We have taken, my lord, the petitions have been opposed by the Union of India, and its main contention is that the Aligarh University, established in 1920 by the AMU Act, and that this establishment was not by the Muslim minority, but the government of India by virtue of a statute, the 20 Act, and therefore the Muslim minority could not claim any fundamental right to administer. So if you're not established, the question of administration doesn't apply. Sorry? Yes, my lord, in Aziz Bhasha, they defended the statutes. Now there is a change of regime. Till 2005, they take the view that this is right. Mr. Gopal Subramaniam, my lord, appeared in the Allahabad High Court, both for the Attorney General as well as the government. He came here, my lord, we came before your lordships. The stance, my lord, in the stay order, which some stage I will show your lordship, was no, Aziz Basha is wrong and the judgment of the Allahabad High Court is wrong. So your lordship said that as far as the reservation is concerned, stop it. And AMU agreed. But as far as the other things that you do, that is within 25 miles of the kilometers of the mosque, you will keep your minority institutions and Muslim institutions intact. Then, my lord, over the page, and this I reserve for my right to reply, I've given two decisions as to whether the stance of the government can be changed or not. And the decisions basically say, if there is a policy change, it's different. But this is more fundamental. There's a constitution in place here. And, my lord, it's idle to argue that before this that took place. Now, there is some discomfiture in the select committee, which Justice Vanchu, my lord, points out. But the select committee majority takes an entirely different view. So, my lord, our view is that the Union of India stance is a defiance of the Parliament's recognition in 1981 that AMU is indeed a minority institution. It's contrary to the pleadings and submissions made before the Allahabad High Court and this honorable court. Now, my lord, I needn't remind your lordship of Sanjeev Coke, which says that mere affidavits, my lord, will not solve the problem. Then, my lord, I sum up in 2.12. It is the duty bound to defend and follow the will of Parliament expressed in the 1981. The Union of India is not going to defend it, having defended it. Then, my lord, it failed to file a justifiable ground for reversing their consistent stand since 1981 at the governmental level and before the Honorable Court and the Allahabad High Court. In these very proceedings, its failure to state that any new material or legal developments to justify this stance is arbitrary, reasonable, and now go to it on merit. Starting with Aziz Basha. But before that, my lord, may I take your lordships to Article 30. Constitution. My lord, the heart and soul of secularism as far as minorities is concerned. Minority protection started in 1909 when reservation was made, 1919, 1935, and of course our constitution. Now we'll have a look at the importance of Article 25 to 30. This is the crux of the understanding of what has to be done in this multi-diverse country. Because take away the diversity, there are all kinds of assimilations that are at present taking place, my lord, in our country. But take away this particular aspect and the entire color of our constitution and governance changes. Now, my lord, kindly come to 25. ऐसे यार कहीं ना कहीं मिल जाएगी दे दो ठीक है Now, my lord, 25 and 26 are important. And Aziz Basha went slightly wrong, my lord, in its understanding of 26. In Justice Kripal's judgment of TMA Pai, he says 26 will also give you a right to establish institutions. Aziz Basha says, since you're out in 30, how can you have a right under 26? Now, my lord, there are two concepts of secularism, my lord, in our constitution. The first comes from 25(2)(a), where it says, regulating or restricting the economic, financial, political, or other secular activity which may be associated with ritual practice. This is where secularism is mentioned. And this is the negative view of secularism, saying that these rights will be subject to secular. This is a very narrow view. The wider view that your lordships have taken on secularism, my lord, which is writ large over your lordship's decisions, is what we understand as part of the basic structure. The narrow view, my lord, simply says you can regulate this activity. Then, my lord, if your lordships have taken you through the 26, 28(3) is important because it mentions aid and that you cannot, because of the aid, that there are some limitations on what you can do. This is now fully explained in TMA Pai and not fully explained in Bhasha. Now, my lords, kindly come to Article 30. I'm not going into the controversies, my lord, of 29 and 30, that 29(1) is a limitation on 30. All that has been decided. It's not. Now come to 1A, we needn't bother about that, my lord. But the main provision of 30, all minorities, whether based on religion or language, this is the diversity provision, shall have the right to establish, this is important, establish what? And administer educational institutions. Now, this has to be read conjunctively. I have no doubt about that. But one point that your lordship should notice is this. What is a minority is something anterior to this. Established and administer are the rights that flow from the recognition of a minority. It's very important, my lord, that your lordship should settle this. Now, my lord, what is it that makes a minority? In my view, my lord, there are three questions. Firstly, the question of origin. Did the origin come from, and where mother provincial effectively is in contrast? I'm sorry, one gets a little excited. Mother provincial says it does not matter even if a single financier comes in para 8, which I'll deal with. That's enough. All this Aziz Bhasha business of not ignoring the antecedency, my lord, is wiped out. The second question, my lord, is the question of nexus, where mother provincial and other decisions take the view that what you have to look at is whether they found the institution or not. And thirdly, my lord, is the numerical test in TMA Pi. Kerala education did not answer that question. We now know that the numerical test is in respect to the state. Of course, some of us who argued Pi and Lord are not particularly happy with this, because we support Justice Uma Pal's decision that it depends on the nature of the statute. But in any case, the majority has held this. Then over and above that, my lord, we have to look at the intention, my lord, of the statute in question. What Aziz Bhasha does, my lord, and I'll take your lordship to the statute, it ignores the purpose of the statute. The purpose of the statute is writ large that it is of a Muslim character. Whereas it goes into the question of establish and administer, it ignores the purpose altogether. Now, my lords, I'll briefly, my lord, indicate to your lordships what my broad argument on Aziz Bhasha is going to be. My lord, Aziz Bhasha is, I'm sorry. Yeah.